If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andrew Rosenberg. Andy helps South Florida families protect what matters most and avoid costly surprises when life changes. I'm Leanne Lyon, and today we're talking about how often you should update your estate plan in Florida. Marriage, divorce, new kids, new homes, or even moving can all throw your plan off track. Let's get into when and why it's time for a review. This is episode 22, updating your estate plan after major life changes. Andy, how often should somebody review their estate plan, and what are some life events that make that update necessary?
Yeah, hey Leanne, how are you?
So good. Great to be
Good,
here.
good, good. Nice to see you again. Okay, so there is no set rule in place with this stuff. So I kind of tell all my clients a couple of things. I tell them one, every 3 to 5 years is when it should be reviewed, your documents, your estate plan. However, my clients, we review them yearly. I try to sit down with my clients once a year to see what's going on. We try to be pretty proactive with our clients. So the general rule of 3 to 5 years. My clients, I recommend once a year sitting down with me to just kind of see what's going on. So that's the rules, the Rosenberg rule, and then the general rule. There you go. Now, what happens, or why should you look at it if it's not every 3 to 5 years or something happens? And I'll give you a good example. My daughter, Allie, just got engaged a week ago.
Yay.
Woohoo! So it's a good thing and it's a bad thing. You want to know why, Leanne?
Why?
It's a good thing because that means she's going to eventually get off my payroll. So that's always a good thing. But the bad thing is that she is no longer going to be my one and only daughter. I got to share her with her wonderful fiance, Jared, and I'm thrilled. And I couldn't ask for a better person. But the point of that is that that's a life event. I mean, that is a big time life event when I get a daughter going to get married. So obviously, if you have a daughter or a son that's going to get married, then that's a big time event. You need to review your estate plan. God forbid they get divorced down the line. That's an event, right? That you have to deal with, or you get divorced down the line. So it's major events. I mean, it's common sense, right? It's you get married, you get divorced, your kids get married, your kids get divorced. You have a new kid that gets born, maybe you're younger. I'm an old fart now at this point. I got a 20, soon to be actually tomorrow, 28-year-old and a 24-year-old. But if you got young kids, right, or a newborn, that's a major life event. Or maybe you don't have kids and you adopt a kid. That's a good example of a life event. And then obviously there's death, and that's always things that happen. So just be, everyone out there, think common sense. All right. If something happens and it's a big deal, then probably we need to readdress your estate plan and think about what's going on and making sure it's up to date.
Well, I appreciate that.
Did that help?
100%. And I actually appreciate you said it 1 year, because those kids have a weird way of sneaking in there within a year. You never know.
Yes, they do. Yeah. Yes, they do. And I will tell you that. Let's see here. I'm going way back, Leanne, but my daughter's birthday is tomorrow, which is November 15th. If you go back 9 months, that's a Valentine's night baby. So they pop out of nowhere.
Out of nowhere. Well, indeed. And then there's other events like moving. So when people move to Florida from another state, because I'm in Minnesota and we know how snowbirds are, why might their existing will or trust not meet the Florida's legal requirements?
Yeah, and that's another event that we didn't talk about. In fact, I live in South Florida. You're up in the Minnesota area, fellow Midwesterner, as I'm from Indiana. But what happens is I have lots of people that I meet with. I do a lot of workshops And so I meet with lots of new people, and a lot of them are coming down from the Northeast or from the Midwest. They're moving down here. They want the warm weather. And so
Mhm.
that's another event. And I tell everybody, when you move to Florida, or it could be any state, you move to Minnesota for you, Leanne, um, that's a life event, and you need to meet with an estate planning attorney to relook at the documents. Why? Because
Mhm.
every state is unique. Okay, every state has their own set documents and ways of doing things. So, and another reason why you should, if you ended up moving, is different states have different rules and laws, especially in the estate planning arena. So, for instance, Florida does not have a state inheritance tax. We don't have a state inheritance tax. If you're in New York and you move down to Florida and you have New York documents, well, New York has state inheritance tax. They actually have city taxes, all sorts of crazy taxes up there. And
Mhm.
if you passed away and you had New York documents, but you're a Florida resident, then New York's going to argue, hey, you were a Florida resident, and Florida's going to argue, no, they were a Florida resident, and now we have this ambiguity out there, and why cause that problem? And you don't want to have the state trying to come after you from New York in that situation. So yeah, there's lots of reasons if you end up moving why you need to redo documents, but that's just one example. Another example is, again, the laws are completely different in
Yeah.
different states. In Florida, one of the big things that we have that's unique is we have Florida homestead laws.
Ah.
So the laws in Florida are very protective with the house. So if you have Florida documents, or I'm sorry, if you have New York or New Jersey or Minnesota documents and you move down here and something were to happen and it is different than what the laws are in the state of Florida, as far as giving away your house, that could cause problems in litigation and disputes and you name it. So another reason to readdress documents when you move to Florida is that the laws are different. And the homestead is a good example of that. Another example would be the actual laws of executing documents in the state of Florida. For instance, in Florida, you have to have two witnesses and a notary sign the documents in front of each other. Other states may not require that. So you want to make sure that the legal requirements are met for the new state and how legal documents are done and prepared. So there are really specific laws in regards to how you do things in the state of Florida as far as signing and executing and notarizing a will or a trust or something like that. In addition, there are special laws in Florida as far as who can become the executor of the estate. We don't
Mhm.
call it that here in Florida. We call it a
Mhm.
personal representative.
Okay.
But to give you an example, that person that you name in your will, maybe you're in Minnesota and you named someone, a friend in Minnesota, and you moved down here and you didn't redo the will, that might be a problem, okay? Because in Florida, you have to be a Florida resident or a relative to be the executor or personal representative.
Mm.
So again, I know this is not the most exciting stuff, Leanne, but it's really important. This stuff really makes a difference. And if something were to happen to you and you were, God forbid, pass away and you have documents in another state, but you were a Florida resident, it could cause all sorts of problems. So the number one rule here to remember, guys, is if you are coming from another state and making Florida your home, meet with someone like me so they can review the documents and make the proper changes to them.
Well, and I personally do find it exciting to think about, I mean, not my demise, but that when that happens, because it's inevitable, that things do go smoothly for the people that I love. And with that, how does marriage, divorce, or a new relationship affect who actually inherits under Florida law if the plan isn't revised as you've just described?
Yep. Again, that we're going back, Leanne, to that, major events that
Yeah.
happen. So Obviously, if you were to get married, if you were to get divorced, that kind of thing, those are major events. So that's when you need to redo things. But
Yep.
a lot of times, this is not high on the list for whatever reason, and they just don't do it or they don't think about it, right? I mean, God forbid you get a divorce. The last thing you're thinking about is redoing my will, right? That's not, you're worried about alimony and you're worried about who's getting the kids and all that stuff and how
Hmm.
much attorney's fees am I going to have to pay to the divorce attorney? So you're not thinking about this stuff, but it does matter. So this is an interesting topic. I can only talk about Florida, but I've seen major problems in other states. So in Florida, if you did not redo your estate planning documents and you got divorced, technically, Florida looks at it as if the spouse or your ex-spouse predeceased you. So they died before you did, so they're not going to get any of the assets. That's what is supposed to happen. The problem arises when you have assets that are not controlled by the trust or by the will. Meaning, what about IRAs and 401ks and life insurance and things of that nature, which have beneficiary forms? And then you still have your ex spouse on as the beneficiary of the life insurance and you die. Who gets it then?
Hmm.
And the answer I'm going to give you is the typical attorney answer is it depends. I can tell you in Florida, technically, it's supposed to be assumed again that the ex spouse predeceased you, and we go to the next person named in the beneficiary designation. I've seen case law in this state and other states that people file suit and say I'm entitled to the beneficiary designation, and it leaves it up to the courts, and so it can get kind of tricky and maybe won't go the way you wanted it to go. So that's yet another reason why it's so important to update your legal documents with major life changes. Got it?
Got it. Well, and some people might not think of this as a major life change. Well, the birth of a child, okay, definitely a major life change, but an adopted child. But when they reach adulthood, not everybody would think of that as being a major life change. So, what updates should parents make when they do have a newborn or their child becomes an adult?
Right. All right. Well, you know what? I want to talk about one other thing before we go there, though.
Sure.
I wanted to mention something. We're talking about marriage and divorce and getting into a marriage and all this stuff. I want to I want to make sure people out there know this that in Florida, if you're not married, you got a significant other, and you've been living together for 15, 20 years, and you have an old estate plan, right? And
Hmm.
it's just you. And you mentioned you want to give everything to your brothers and sisters. You're not married. You just never got married, that kind of thing. Your significant other has zero rights. So that's a problem. And I see it all the time. I've had many clients, unfortunately, come in where they were the significant other, male, female, whatever, it doesn't matter.
Hmm.
And they lived together forever. And then all of a sudden, the person that they had as their significant other passed away. And the family comes in from the deceased person and they want to kick them out of the house and take everything. And I have to tell them that legally you have no standing and that you're done. And so there is a big difference between marriage and not marriage. And if you have a significant other, then estate planning is vitally important, and making sure you stay up to date with the estate planning is vitally important. So I just wanted to make sure I put that to bed. Now let's go on to your question, which was what happens if you have an adult or you have a child that becomes an adult, right?
Yeah. Yeah.
Do you need to do anything? Or what happens if you have a newborn or an adopted child? Is that what you said, I believe?
Yeah. Yeah. With all the child ish,
Okay. So
milestones.
yeah. So most of the time, obviously, we want the kids once they hit majority age, which is 18. We most people feel like, okay, I want the kid to be in control or handle things and to be the executor or personal representative, be my healthcare surrogate, be whatever it might be. Well, th- that's great, but It's not going to happen unless you readdress the documents. So when the kids hit that age, it's yet another milestone, yet another important event. So maybe that's when you need to meet with someone like me again and sit down and say, hey, Andy, my son, Jason, just hit 18 years of age, and I feel like he's competent and that he's mature. I want him to be the person in charge. I don't want my friend John handling things. So I'm like, no problem. We got to redo the will. We'll do a codicil to the will. We'll do an amendment to the trust, but we're going to probably have to redo your durable power of attorney, your health care, those types of things. So when that stuff happens, we're probably going to have to redo several documents and do amendments or codicils to the wills and trusts. As far as having adopted children or new children, let's say we've done an estate plan and then you have a new child come into the picture. I can only say what I do in my documents. My documents are prepared for that situation. So it mentions that if you have any kids or future kids, they're going to be part of the inheritance. It really depends on your legal documents. So that requires an attorney to review them to make sure it's up to date. So if you do adopt someone or you do have a new child coming in and that was born, congratulations, obviously, but we should probably sit down and just make sure everything's in place.
So, for somebody who hasn't looked at their plan in years, what's the best way to check if it still matches their current situation?
The best way is to sit down with an attorney, obviously. I mean, I can't stress enough how important it is to just sit down. Listen, I normally don't charge if it's a free consultation for a meeting. I have clients come in with their estate plan and I review it. And
Okay.
there's no cost for a review. Some attorneys are going to charge. I'm $600 an hour, so you may have to pay $500-600. It's money well spent just to make sure everything's put into place. Because God forbid if something happens and you pass away and it's not going to go the way you want it to go. I mean, you won't know, but the family's going to be in shambles because things are not going how they thought it was going to go. So it's really important to basically just sit down with a competent estate and elder law attorney to deal with these things. Listen, this stuff's not exciting. This topic's not the most exciting stuff. I get it. We've done more exciting stuff on prior episodes, but this stuff is important. It's stuff you really need to deal with because if you don't, I see it every day, guys. There's going to be conflicts. If there are conflicts, that means someone usually hires an attorney, the other side hires an attorney, and then we got disputes and we got legal litigation and we got money going out to the attorneys, not to the family. So be smart, guys. The old saying, don't be penny wise and pound foolish. Spend a little bit of money, meet with an attorney, just make sure everything's in place, and you'll be thankful for that.
100%. And as we're kind of getting towards wrapping up, one question is, do you have to start from scratch every time?
Nope, absolutely not. That's why you need to bring in your documents and you tell us, listen, when I meet with people, I call it a vision or a discovery meeting. I want to know what's going on, what I'm trying to discover, what your concerns are, what your goals are. And a lot of times what you already have in place might be perfect or it might need just a little tweak and we just tweak it and you're good. It doesn't mean you have to spend thousands of dollars every time you meet with someone like me. Sometimes it does, okay? And there's a reason for it, but a lot of times it's okay. And remember, it's not just the will, it's not just the trust, it's your durable power of attorney, it's your healthcare surrogate, it's your living will, it's your HIPAA documents, it's your beneficiary designations, it's all these things that make a difference for your estate plan. And it's something that's really important to take care of.
Perfect. And you have a really great resource that people can also check out, right?
I do. I just wrote a book, so it's out there, guys. It's on Amazon. It's called, are you ready?
I'm ready.
Are you ready?
I'm ready.
If
Yes.
you don't plan, you're stupid. And believe it or not, Amazon's giving me a hard time because I have people buying the book and they're writing reviews and they're putting the word stupid in the review because they like it. And Amazon's flagging it and they're not allowing the reviews. So remember, the book is called If You Don't Plan, You're Stupid. And the podcast is called the same thing. But it's really a down to earth discussion about what is important for estate planning. I think it's worthwhile. It's Florida based, guys. So just realize it is Florida based. But thank you, Ann, for plugging that. I appreciate it, even though I had a brain fart.
It's all good. That's what's so great about this is just, real life, real people talking real ways. So thank you for listening to today's episode of If You Don't Plan, You're Stupid, the podcast. Life changes fast and your estate plan should keep up. If you've moved to Florida, remarried, or just haven't reviewed your plan in years, visit rosenberglawfirm.net to make sure it still protects what you care most about. And don't forget to like, subscribe, and leave a review if you found today's episode helpful. Thank you, Andy.
Thanks, Leanne. Appreciate it. And don't forget, guys, root for the Hoosiers. Go Big Ten. Go IU.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.